but let's start first with Grants Pass v. Johnston. This is a question as to whether laws, broadly speaking, prohibiting camping on public property constitutes cruel and unusual punishment, which of course is a prohibition under the Eighth Amendment. Mm-hmm. And so walk us through this case. It's an interesting case. It's also sort of weird in the way that the plaintiff brought it, it seems to me, but walk us through this.
Yeah, I mean, the big picture is that a lot of West Coast cities, Grants Pass, Oregon is the one in question, but this includes San Francisco, just don't have enough shelter beds for their unhoused population, which forces people onto the street, generally into homeless encampments or just camping on their own. And the municipalities have laws that basically say you can't camp. It's a criminal offense to camp outside, and they define it in different ways. And that leads to police coming in and clearing them out by force. And a few years ago, the Ninth Circuit, in a case called Martin v. Boise, basically held that you can't do that unless you have adequate shelter beds, right? Because there's nowhere for these people to go. It's just unnecessarily cruel. You're just saying you have to leave, you have to pick up your stuff and go, but there's nowhere to actually go. The city is not providing them with anywhere to go. So that's cruel and unusual punishment. So this is basically that case risen to the Supreme Court. They turned it down in 2019, but we are now post RBG and things have changed up there. So basically, the advocates for homeless people, for unhoused people, have been pushing this claim that this is all a violation of the Eighth Amendment, that this is cruel and unusual punishment. And I think the core of the argument is this idea that this discriminates based on status rather than conduct. There's this case in the 60s, Robinson v. California, that basically said, you can criminalize drug use, but you can't criminalize being a drug addict. You can't criminalize addiction, right? You're criminalizing someone's status. And so we had a whole oral argument about just the most inane, hair-splitting distinctions about, like, well, are we outlawing homelessness or are we outlawing sleeping outside? And what's the difference there? Clarence Thomas believes that there's a real difference. So this oral argument was torture to listen to. It was a real good lens into what being a lawyer is like, where you have to hear these just obviously terrible arguments. But that's the fundamental argument there.
And wasn't the plaintiffs also arguing that the prohibition on cruel and unusual punishment is in the actual punishment rather than the implications? In other words, like almost like the difference between a verb, like when one's an active verb and one's an inactive verb. Like the punishment of you get a fine for camping is not, as an isolated way, necessarily cruel and unusual, except for the fact if you know that the people don't have any other place to be, that it's actually like that was the weird part that it struck me, I guess.
Yeah, I mean, that's sort of the heart of the advocate's argument, that this actually it's cruel because there are no shelter beds being provided, right? If you had a situation where these cities were providing adequate resources to unhoused people, then you could argue that it's not cruel to not let them camp outside because we have this perfectly reasonable, safe place for you to go. But if they're not providing that, then it's necessarily cruel, that all you're doing is taking these sort of necessities that they have, confiscating them or dismantling them. I mean, it was compared by the liberal justices in oral argument to any other necessity, right? Can people eat outside? Can people go to the bathroom outside if there's no public toilets available to them and they have nowhere else to go? I think the argument's sort of intuitive. It's just cruel by its nature, right? These are people who need to sleep outside because they have nowhere else to sleep.
And to Sam's point, I think, Sotomayor made that argument, right? Which was that I fall asleep on the beach, and how is that a different kind of category? I'm not going to get arrested when I fall asleep on the beach, but somebody who falls asleep in a public park is going to do so. And so how does that not constitute criminalizing homelessness as a status? And they didn't really have a great argument for that. They just kind of skirted the question.
Yeah, I mean, Sotomayor was pointing out that even if you think this isn't criminalizing homelessness, what the state was saying, what the city was saying was, well, we're not criminalizing homelessness, we're just criminalizing sleeping outside, right? And so Sotomayor was sort of saying, well, are you really getting anyone else on this, right? Or if someone who's in business casual falls asleep on a bench, have they ever been ticketed for that? The answer is pretty much just no. The city has like one example of someone who technically had an address, and I don't know if that meant that they actually had access to that home, but it's very obvious that even if you sort of want to do this hair splitting between, what's the difference between someone who sleeps outside and someone who is homeless, that it's just only being enforced against people who the police think look like they don't have a home.
Yeah.
What's your sense of how they dispose of this case?
Well, the conservatives hate the Eighth Amendment. This is a long-standing thing. 25 years ago, we had Antonin Scalia saying it's not cruel and unusual for an innocent person to be executed. I mean, this is like part of the conservative jurisprudential tradition to just never really expand the Eighth Amendment. So I would be shocked if they bit on any Eighth Amendment argument. There is sort of a third way that Gorsuch and Kavanaugh and Amy Coney Barrett were pushing, which is basically, well, instead of making this an Eighth Amendment thing per se, can't we say that this is what's like in the law a necessity defense? This is something that like comes up in criminal law where basically if you have a real human need to commit a crime, that can be a defense for that crime. So, stealing a loaf of bread when you're starving is, of course, the classic example. But like here, what they're saying is, well, couldn't these just be raised as defenses after the fact? I wouldn't be surprised if that's where the conservatives go with this one, but really a non-starter, I think, from the advocates' perspective. I mean, the bottom line is this means that police would have the right to clear homeless people out from where they're sleeping. And then like in court, the people can raise the defense of necessity. In my mind, it's just sort of a distraction, but I wouldn't be surprised if that's where the conservatives go with it.
And so we are basically making it, in that event, just to be clear, it is essentially illegal to be homeless. But there are mitigating circumstances where you may not have to serve time, essentially, is what it comes down to.
Right. And I mean, to be clear, most of these situations don't involve anyone serving time. I mean, if you look at the Grants Pass examples, it's not quite as visceral. But if you look at what's happening in San Francisco, which is where the heart of this political battle is, where you have the mayor complaining about these laws, these cases, you basically have situations where the police are just coming in and clearing out encampments, right? They confiscate tents, they tell people they have to leave, and that's it. No one's really getting arrested in these cases. The police are just utilizing the authority of the law. So the necessity defense really does nothing for someone who's just trying to stay somewhere during the night.
Right. These laws just end up being, I guess, a vehicle to immiserate people more than than they are at that time. God, it would be horrible if it forced actually cities to provide housing for that. That would be what a novel way to approach that problem.
That's what's so frustrating about this case is that we have like Gavin Newsom and his political allies complaining about these sorts of cases. All they have to do to make this go away is provide adequate shelter for their unhoused population. That's not something they're willing to do. or able to do for whatever political constraints they claim. But that's the sort of obvious everyone wins solution. And I mean, I wouldn't even say everyone wins because you have problems with the shelter system, but that's a solution available to them that they're just not ready to utilize.